Hi, everybody. I'm Nazgul Gandnoush, co-director of research at the Sentencing Project and lead author of our report on felony murder, which we co-published with Fair and Just Prosecution. Thank you so much for joining us in this discussion about the harms of felony murder laws and reform efforts. I'm delighted to introduce our panelists to you. So with us today is Marshan Allen, the Vice President of Advocacy and Policy at Represent Justice. Thanks to the U.S. Supreme Court's decision in Miller versus Alabama, he was released from prison in 2016 after serving almost 25 years for his minor role in an offense that occurred when he was 15 years of age. Mr. Allen has become a staunch advocate for criminal justice reform and has received numerous awards and recognitions for his advocacy. Also with us today is Kate Chatfield, who's the legislative director for California State Senator Nancy Skinner. She was previously the chief of staff for San Francisco District Attorney Chesa Boudin. She also worked at Restore Justice, where she was the lead drafter and organizer for Senate Bill 1437, which amended California's felony murder rule. Also here is Iko Yanka, who's the Thomas M. Cooley Professor of Law at the University of Michigan Law School. His work focuses on questions of political and criminal theory, and particularly questions of political obligations and justifications of punishment. He also serves on the board of the Innocence Project. A slight change in our program, Miriam Krinsky will not be able to join, but in her place, we're fortunate to have Monica Fuhrmann, who's the Director of Research and Outreach with Fair and Just Prosecution. She joined FJP after spending 3 years with the Pew Charitable Trust Public Safety Performance Project. Also with us is Justin Kollar, who's Fair and Just Prosecution's Chief of Staff. Mix Kollar served as the elected prosecuting attorney for the County of Kauai, Hawaii, from 2012 until 2021, where they managed an office consisting of 45 in a county of 70,000 residents. They're also currently serving as a volunteer attorney with the Hawaii Innocence Project. So I have a couple questions for our panelists, and then I'll open it up for the audience. But before I get to that, I want to present a brief overview of our felony murder report. All right, here we go. So let me start with the definition of what I mean by felony murder. So felony murder and murder are distinct. Murder is, generally speaking, is an intentional killing, and felony murder is a legal fiction that turns something else and treats it as if it was an intentional killing. And so the classic example, I think, is when a group of people are committing a robbery with a gun. And so one person is pointing the gun at the victim, and let's say a scuffle ensues and the gun unintentionally goes off and the victim is killed. In that situation, the person who was holding the weapon, as well as everyone who was helping them to commit the robbery and serving as a lookout or as a getaway driver, can be prosecuted for felony murder. And so what felony murder laws do is they impose sentences associated with murder on people who neither intended to kill nor anticipated death, and even on those who did not participate in the killing. So when it comes to accomplices, what felony murder laws do is that they punish people for being present when someone was killed because they participated in a related felony. We at the Sentencing Project came to this issue because we think a lot about what we need to do to end mass incarceration. And we know that at this point, we are marking 50 years of mass incarceration. The first 40 years, roughly, the prison population was going up dramatically. And in the last decade or so, the prison population has been coming down, but we're still squarely within the realm of mass incarceration. But what we know when we break down the prison population by offense type and look at how these trends appear by conviction offense, there are two very different stories. Most of the progress that we've made in reducing the prison population has been in reducing the number of people in prison with a drug conviction or a property conviction. And so when you look at those offenses, since reaching their peak levels, we've made a nearly 50% cut in the population that's in prison for those crimes. But when it comes to violent crimes, we've barely made a dent. And the prison population with a violent conviction has come down only by about 10% since reaching its peak level in 2009, even though violent crime rates fell dramatically since reaching their peak levels in the 1990s. So between the 1990s and 2019, homicides fell by 50%. So did other kinds of violent crimes. And yet we barely made a dent in the number of people in prison with a violent conviction. And that has to do partly with the fact that sentence lengths have increased dramatically. And one way we know that is if we look at the number of people in prison with a life sentence. So thanks to my colleague Ashley Nellis's research, we know that 1 in 7 people in US prisons is serving a life sentence. That's a sentence of life with or without parole, or a virtual life sentence of 50 years or longer. That's over 200,000 people. That's more people than were serving a prison sentence of any length in 1970. Felony murder laws are an on-ramp for extreme sentencing. And one way we can see that is by looking at how states allow or require life without parole sentences for a felony murder conviction. Based on our survey of state statutes, we found that 9 states in the federal system mandate LWOP, life without parole sentences for a felony murder conviction. 15 states mandate them for some felony murder convictions, but not all. And 16 states and DC make LWOP a sentencing option for a felony murder conviction. In addition, 5 other states permit or require a virtual life sentence of 50 years or longer for felony murder. So you can see how felony murder laws contribute to extreme sentencing. And here are some concrete examples of this. So in Pennsylvania and Michigan, 1/4 of people serving life without parole sentences were convicted of felony murder. In California, approximately half the LWOP population was convicted of felony murder. And in Minnesota, 1/3 of individuals who were incarcerated in 2021 who were given a life without parole sentence were convicted under the felony murder doctrine. So here are some of the problems with this legal theory and this practice. So I'm going to cover a couple different issues, but first I'm going to start with the fact that extreme sentences are counterproductive to public safety. So there's an overwhelming amount of criminological evidence that shows that very long sentences they don't help to protect public safety, but they're also counterproductive, and I'll explain why. So they don't have a positive effect on public safety because people age out of criminal activity. And so imprisoning people past 10, 15 years means that we're incapacitating people in prison who no longer, generally speaking, pose a public safety risk. In addition, long sentences are not effective deterrents to criminal activity because most people, not unreasonably, do not expect to be apprehended and do not expect to face these penalties. And the counterproductive part fits in because these kinds of sentences put upwards pressure on the entire sentencing structure, make all sentences longer, and they also distract us from much more effective investments that we could be making to prevent crime from happening in the first place. And a lot of those investments are ones that need to happen outside of the criminal justice system. And with respect to felony murder laws specifically, there have been a handful of studies that have found that felony murder laws do not have a significant or consistent correlation. There's no consistent or significant correlation between felony murder laws and crime rates or crime-related deaths. So the second problem with felony murder laws has to do with the principles of our criminal code. And one of those principles is proportionality, that the more serious the offense, the more serious the punishment. And part of that seriousness of the offense has to do with someone's intent. If someone committed a very serious amount of harm but did not intend to do that, we generally punish that less severely than when there was intent. And so felony murder laws completely upend that principle, and they make it so that people who committed unintentional killings are treated as if they committed intentional ones. And in some cases, we have really egregious examples of how these laws are applied. And that's when crimes like burglary, drugs, or assault are used as predicates for a felony murder charge. And in some situations, like, for example, with Lakeith Smith's case recently in Alabama, which has gotten a lot of media attention, We have instances where a group of people committing a felony experience one member of their group being killed by police officers, and the group committing the felony is then charged with felony murder for someone outside of their group killing someone within their group. And so it's examples like this that led Giora Binder, who's co-authored a paper with Professor Janka, who'll be presenting later. It's examples like this that led him to conclude that if the felony murder doctrine is designed to produce results like these, then it should indeed be abolished. And we'll talk more about that later. So the third problem of felony murder laws is that they disproportionately impact people of color, young people, and women. And I'll present some statistics about the disparate impact on people of color in just a second. But let me say about the disparate impact on young people in particular and why that's so significant. And that's because young people disproportionately commit crime as a group. And so that brings in more people that can potentially be held liable for a felony murder charge. And in addition, the idea of felony murder is that if you're committing a crime and you should have foreseen this very unlikely outcome, that is an especially unreasonable expectation to have for young people who are especially ill-equipped to understand the consequences of their actions. So with respect to racial disparities, here's a bit of information about that. In Pennsylvania in 2020, 80% of people imprisoned with a felony murder conviction were people of color, and specifically 70% of them were African American. In Ramsey and Hennepin counties, an analysis that was done of felony murder charging found that the practice was racially inequitable, in that for white defendants, felony murder convictions often represented an opportunity to plead down from something more serious, whereas for defendants of color, felony murder convictions often represented the most serious charge. And in California, we know that prosecutors are more likely to bring murder charges under the state's special circumstances law, which includes felony murder and imposes a mandatory life without parole sentence against people of color and in cases involving white victims. And then the last problem that I want to talk about with felony murder laws is that some of the reforms that we've seen around the country seem to are very limited in tackling the problems that I've been describing. So for example, reforms in Colorado, Illinois, and Massachusetts seek to scale back the felony murder law to some extent to varying degrees in these states, but they have not been applied retroactively to people that were sentenced under the old law and convicted under the old law. And then some states like Michigan and Massachusetts have added a mens rea requirement, an intent requirement to bring felony murder charges. But it seems as if these requirements do not do much to restrict the law, because just for example, in Michigan, having a gun or knowing that your accomplice had a gun is sufficient to meet the intent requirement. And so most felony murder charges that would have been brought there are still able to be brought. And there's a concern that this is the case in Massachusetts with their recent reform as well. So what do we recommend? In our report, we recommend abolishing felony murder laws completely. And in the absence of that overhaul, we recommend ensuring that felony murder convictions result in less harsh punishment than intentional murders. That's to restore proportionality. We recommend eliminating the application of felony murder laws to predicate offenses that have an extremely low risk of death, and that includes robbery, as well as burglary and drug law violations. We also recommend making meaningful intent requirements for a killing to be considered a felony murder. And so I'm going to stop there with my overview. And I'm going to turn it over now to our panelists. And I'm going to start with a question for Marshan Allen. So Marshan, can you tell us about, in your testimony to the Illinois legislature that I was reviewing, I saw that you had written, Illinois has created a sentencing system that does not account for our humanity, our dignity as individuals. So can you tell us about the experiences that led you to that conclusion?
Yes, absolutely. Thank you, Nazgal. As you know, I was convicted of felony murder here in Illinois and served almost 25 years. During that testimony, I was specifically speaking about the range of policies in the state of Illinois that prevent people from being seen as growing and changing human beings. As I mentioned, being convicted of felony murder, sentenced to life without parole, and because of the circumstances of my case, namely that I was 15 years old and charged with murder, I was automatically charged as an adult and sentenced to 2 mandatory terms of life without parole. And that happened in spite of the fact that the judge wanted to impose a less harsher sentence. And during my 25 years incarceration, I had met other people who had similar circumstances. So what I was referring to during my testimony was the reality that Illinois had created a system where people could be automatically charged as an adult with murder and sentenced to die in prison without any individualized consideration for the person, such as their age, the minimal role in the offense, the lack of intent to cause any harm, and even their potential for rehabilitation or any other factors that would have been relevant before, someone make that decision. But, as we know, that problem of failing to recognize people's humanity and dignity isn't unique to my home state. Unfortunately, this is a problem that exists throughout the United States. Take for Alabama, you mentioned the case of Lakeith Smith. My organization I work for, Represent Justice, we are currently helping lead a campaign for Lakeith Smith, the Justice for Lakeith Coalition. And to give you some context about what happened with Lakeith, as you mentioned, like 2015, Lakeith was 15 years old at the time. He and his friends were burglarizing home trying to steal video games. A neighbor spotted them, called the police. And when the police arrived, they actually shot and killed one of the boys, Lakeith's friends, Dante. And Lakeith and the other boys were actually ones that was charged and convicted of felony murder. Lakeith was originally sentenced to 65 years in prison, and that sentence was recently reduced to 30 years, which is less than 65, but it's still a very excessive sentence for a child who was only stealing video games. And also, because of the felony murder rule, he would now be branded as a murderer for the rest of his life. And the question I have is like, why? This is not fair. This is not just. And it's completely unnecessary. And more importantly, as you mentioned, Nazgal, is that it doesn't make our community safer. So this is what I was referring to when I was speaking about the sentencing systems that don't account for our humanity and dignity as individuals. This false idea that we as a nation, and that in order for us to feel safe, we feel that we have to impose the most serious charges. We have to impose the most extreme sentences, regardless of the circumstances. And I believe that this is like a direct consequence of our inability, or at least our unwillingness, to recognize and respect people's humanity and dignity. And this is one of the most basic elements that I believe is universally missing from our so-called justice system.
Thank you so much. And thanks for elaborating about Lakeith's case. And so you benefited from the U.S. Supreme Court's ruling that mandatory life without parole sentences for youth are unconstitutional. Can you give us a sense from the people that you met during the time that you were incarcerated and sort of your impressions since then during your advocacy of whether others who were convicted of as adults deserve a similar, customized review, deserve a second chance? And tell us more about your advocacy work.
Absolutely. And thank you again. I met, over the 25 years that I spent in the Illinois Department of Corrections, I've met a lot of incredible people during that time. People I credit with me being the person I am today. People I credit with me having the knowledge I have of the law and being able to fight and for myself to get out of prison. These people shape almost every aspect of my life. I grew up with them in prison. A lot of us entered as juveniles and became men, and then middle-aged men while in prison, unfortunately. But there are a host of people that I knew, even some that I didn't know, who, because they weren't 18, Miller versus Alabama only applied to people who are under 18 so far. They're still in prison, and they definitely deserve a second chance as I do, even the ones who were adults. Some of the people I know that were like 20, 30 years old at the time they committed their crimes. There are also people who are deserving of a second chance. And a lot of them have committed harm, and I'm not advocating for, a system that people are not held accountable, but what I'm advocating for is that opportunity for people to be seen as individuals, opportunity for people to prove that they have redeemed themselves and have opportunity for a second chance. And as far as like my advocacy work, as I mentioned, like right now we're working in Alabama for the Justice Lakeith case. That's one of the cases that's dealing with felony murder. I previously worked here in Illinois for an organization called Restore Justice, ironically, Restore Justice Foundations, and we were able to fight to limit the Illinois felony murder rule here recently. But with the Justice for Lakeith case, we're working with a coalition of people there. We are also hoping to introduce a bill soon that will limit it. It won't completely abolish the felony murder rule, but it would limit, specifically, it will prevent convictions for death caused by third parties, like in Lakeith case. And it also limit the number of felonies that trigger the felony murder rule, and actually lower the sentencing range as well. So that's some of the things that I've been working on. Even working with the CFSY, Campaign for Sentencing Youth, to help abolish life without parole as an ICANN member. So those are some of the things that I've been working on, and people that I've met while I was incarcerated who I think that deserve a second chance. Even though they have committed harm, they deserve to have a second chance to be with their families and to redeem themselves and make a contribution to society.
Thank you so much. That's very powerful to hear about you crediting the folks that you were incarcerated with, helping you to, in your maturity and in your development. That's really notable to hear. So I want to turn over to Echo, and I'm wondering if I've been waiting for a while to ask you this question ever since I saw your law review article. And so in the article that you co-authored with Gira Binder, you state that as co-authors, you walked a ways together and learned from your differences. And ultimately, you reached the conclusion that legislatures should abolish felony murder wherever racially disparate patterns of charging can be demonstrated. Can you tell us about this walk and how you reached this conclusion?
Sure. Thank you for having me. It's really a thrill to be with such a great group, and I took a lot from Mr. Allen's, from Marshan's words. So Gira Binder it was terrific to have an opportunity to co-author with a scholar who's not just a friend, but a scholar I admire greatly. He is almost certainly, almost unarguably, the person who knows the most about American felony murder law. And one of the interesting things about Gira Binder is, Professor Binder, is that despite his great misgivings about the felony murder rule, he's also one of the few scholars who had not been, or is not at times, let me say, had not been unequivocally against the felony murder rule. So Gira has actually been very thoughtful about reasons why the felony murder rule, although it has many of the flaws that almost the entire academy is universally against, he was one of the people sort of on the barricade saying, it's not great, it's not anything like perfect, but there are reasons why some felony murder convictions are plausible. And one of the reasons I like working with him is I thought he gave voice to those concerns in very thoughtful ways. So you've named the kind of classic felony murder case, somebody's the lookout, and somebody gets accidentally killed, and now the lookout is being considered a murderer. And Marshan, you gave other great examples of a child is stealing video games. And we can say that, this person has done something wrong without calling them a murderer. And we should be thoughtful about that. Another kind of case that jumps to mind is Stavion Rodriguez's case recently in Oklahoma, where he and a friend were robbing a gas station. And this is a very dangerous thing to do. And none of us, as you thoughtfully pointed out, are giving any solace to that. But this is a young man who then gets caught. He's quite young, he's hapless. The police surround the station. In fact, he's such a hapless burglar, the police are kind of making fun of him. It's all caught on tape. And they order him out of the station. He comes out with his gun held over his hand. The police order him to put it down. He puts it down. And then suddenly 13 different police officers start shouting different orders at him. And he essentially just flinches, and they open fire and they kill him. It's his friend who had already run away from the gas station who was then prosecuted with the felony murder charge. So those are the classic cases that give us reason to think, give us good reason to understand why felony murder is so misused. What did Gira point out, or what does Gira point out? Let's take another kind of case where actually felony murder might be sensible. So let's say you and I are engaged in a robbery, the police appear, and we open fire on the police, and the police return fire, and a police bullet kills an innocent bystander. Well, those are the kind of cases where people might say something like, even though you didn't intend to kill, or you didn't intend to kill that person, your actions were so close to murder, so sort of discarding the safety of others around you, that we think it's not totally unjust to call it murder, right? This is how I teach my felony murder cases. Somebody who sets fire to a home and they say, well, I didn't know there was a third person in there. And we say, look, when you're so disdainful of human life, we think those are cases where your actions are so awful that maybe we think it's murder. And that's what Gira Binder, I thought, thoughtfully highlighted. One of the things that Gira and I worked on and thought through was, even in the cases where felony murder is the most morally defensible, do we really need a felony murder statute? And we came to the conclusion that no, we just don't. In those cases where felony murder really does seem like something we can say, this is not a gross injustice, it's true that the law allows us to prosecute people as murderers for different reasons. We call it extreme indifference to human life. When your actions are so extraordinary that, for example, you open fire and somebody has to open fire back, you can be charged as a murderer under old common law rules. And so one of the ways in which Gira and I really had to think through things together was how to rescue the intuition that some of the worst cases really do seem like your actions, at least we can inspect them for murder, without allowing the excesses, the cruelties, and the injustice of the felony murder rule as it works today.
Thank you so much for clarifying that. And so I guess a follow-up question I have sort of two follow-up, I guess I'll combine my follow-up questions then, is how race fits into this, because, you know, the racially disparate charging patterns is part of what compelled you to argue for abolishing felony murder laws. And yet we have a few instances where felony murder laws have been used to bring about accountability when police officers or others have killed, in particular, Black men unjustly. And so how do you reconcile those, that it could potentially be, as some see it, and as, you know, in some cases, like with the officer who killed George Floyd, a tool for bringing about accountability? How do you reconcile that?
Sure. So I gave a sort of long professorial answer about how Gira and I came to the conclusion of why felony murder is not needed. But your question really points to the most important part. How do we know that felony murder is not needed? Because as I've tried to hint, we can take seriously the kind of cases where felony murder is most tempting and find ways to prosecute it without the kinds of wrongs that send young people, in particular young Black men, to prison for long, long times, and often do so in ways that obscure reckless or racist policing. Police actions where the police take actions they never would in a community that has power, right? Sting operations that are explosive and bound to go wrong. Police officers, you think of the Tamir Rice case where a police officer drives up and opens fire within seconds. Police officers too often can obscure reckless and violent policing under the felony murder statute, right? By, as has been pointed out, by shifting the blame to other co-defendants. Now, I say we know we don't need the felony murder rule because one of the things we found out is, despite the temptation in a high-profile case like the George Floyd case, where now you've prosecuted one police officer for one incredibly searing killing under the felony murder rule, and that feels like a victory, we forget how often, as we just pointed out, that same felony murder rule actually allow police violence to not only be shifted on to another person, but to be hidden entirely from public view. So I gave you the Stavion Rodriguez case where he's gunned down by police officers while he's surrendering in front of a gas station. It's important to know that the prosecutors in that case were going to charge his friend who had already run away as the murderer, until activists protested for weeks and weeks, and the video came out and were circulated in Oklahoma. And only then did the prosecutor step down and decide, oh, something's going wrong here. Without the particular combination of things occurring, another police killing would have just been foisted onto somebody who it's easy to call the bad guy, right? Some criminal here. And more importantly, that happens most often in cases where the defendants are Black men. And so the reason the disproportionality matters to us, and the reason it connects to the first question, is one of the ways we know that we don't need a felony murder doctrine is because we don't use it when it's white people, right? I'm being a little bit provocative, because of course there are lots of white people who have been in prison under felony murder. But as you so helpfully captured in your run-up to our conversation, the felony murder rule is disproportionately used when it's aimed at Black defendants. It's disproportionately used to make murder the most serious charge that those defendants face, because you couldn't prosecute them under anything like that kind of seriousness if you were actually looking at the elements of their crime. And we know that when white people commit these same crimes and have these same results, we then turn to a criminal justice system that says we have to punish them proportionately. So if we can live without it in the case of white defendants, then I'm certain we can live without it in the case of sending young Black men away for the rest of their lives.
Thank you so much for sharing these insights and for your great work on this issue. So I'm going to turn over to Kate now. And Kate, I'm wondering if you can tell us about the reforms that have happened to the felony murder rule in California, both in the legislature and in the courts.
Yeah, thanks for this panel. Thanks everyone for all your good work in this area. I did just want to start sort of where we are now in California, which is yesterday, the CDCR released the numbers of people who have been resentenced as a result of California's felony murder reform. And the official numbers are resentenced under SB 1437 are 609 people. We think that it's probably closer to 1,200 people. It's about double that, because a lot of people go back to court, and then there are, plea negotiations with district attorneys, or they're resentenced in different ways. But even accepting that it would be 609 people, those are 609 people that have life sentences that have been released from prison. So it's always very heartening news. What happened in California was that we had sort of a grassroots coalition of organizers, some I think who are probably on this webinar, Joanne Shear from the Felony Murder Elimination Project, California Coalition for Women Prisoners, Anti-Recidivism Coalition. So these grassroots activists, and I think they were combined with lawyers who sort of had been reading the court cases, seeing how this had been evolving. And we had a great Senator Nancy Skinner, who was energized about this. And we had a great governor at the time, Governor Jerry Brown, who was also very energized about amending the felony murder rule. So we started in it was a long process. It was a really long process. And I say really long because we had court cases in the California Supreme Court from 1965, People v. Washington, saying felony murder needs to be eliminated. It's a terrible rule. 1983, Justice Stanley Mosk, in a case, People v. Dillon, about the felony murder rule, saying we'd love to eliminate it. He called it barbaric. He said it separates moral culpability from individual liability, and it's wrong, but we can't do anything. We're calling on the legislature to do something. That was in 1983. So 35 years later, we got felony murder reform. So because of course, then during the 80s, we had the tough on crime era, there was not going to be any real serious reform, let alone for something with such a bad marketing name as felony murder. It just doesn't sit well with people that we would be reforming this, of all things. So the first aspect of this work was to, with the grassroots organizers, was to really educate the legislature about what this rule is. I mean, the legislature, they're not lawyers, let alone criminal, lawyers. So we started in 2017 with a concurrent resolution, SCR 48, just sort of laying out, it doesn't do anything other than it passed the Senate and the Assembly saying this is a rule. It's not only felony murder, there are some other common law doctrines where you don't have to have malice to be guilty of murder. It's called the natural and probable consequences doctrine. There's second degree felony murder in California. And we need to combine liability with culpability, and we're sweeping up too many people in our murder statutes, or in our murder prosecutions. So we went through that, we got that passed through both houses in 2017, and then we were ready in 2018 with what became Senate Bill 1437. So there was a lot of on the ground organizing around that. The first thing that we had to do is we had to get some numbers, because in California, maybe as in most states, when you get sent to prison, it just says first-degree murder. It doesn't say under what theory of murder you were tried. So we had organizers send surveys into prisons, and get clergy people and chaplains would get these surveys into prisons, and then we would get them mailed back, and we would ask people, how old were you? What was when you were convicted, what was the underlying felony? How many co-defendants did you have? And were you the actual killer? That's our under our statutes, the actual killer. Or were you a non-shooter? So we got those back. We found that it was not surprising. It was mostly young people. Young people, for various reasons, tend to act in groups. The vast majority of underlying felonies are robbery and burglary that form the basis for felony murder liability. Found that 72% of women who were convicted of felony murder were not the trigger person. They were the co-defendant. So it was disproportionate on Black men, Latino men, and women. So we had these numbers, and then we just went through the legislature. We had to, follow, we have voter initiatives in California. So we had to sort of weave through some of those voter initiatives so that we could actually have the legislature act. And people cannot be convicted of felony murder unless they were, again, an actual killer, acted with reckless disregard for human life, and as a major participant in the felony. This came from a lot of really, really good California Supreme Court cases that had sort of defined what that is. So, for example, just being armed during a felony doesn't mean that you are acting with reckless indifference to human life. That's, as the Supreme Court said, that's a garden variety armed robbery. There are lots of armed robberies. They don't all end up in murder. You have to show something more than that someone acted with reckless indifference, personally acted with reckless indifference to human life. So, and that, those were not only good for our future court battles that we had, because this law was, of course, challenged by district attorneys, to show how we were, hewing to case law, but it was also good to get it through the legislature, I think, for the reasons that Professor Yanka raised, that, we have to, there are, some actions that do exhibit reckless indifference to human life, and that do rise to the level of murder. Now, they could be also prosecuted under different theories that we have here in California, what we call implied malice, et cetera. So we did that, and so at all times, like I said, we were working towards getting it through the legislature. The governor was incredibly important, and then 35 years to the month that Stanley Mosk wrote People v. Dillon, Governor Brown signed SB 1437. So it was a very long process. And then we had a whole process of implementation. Getting, it's one thing to get a bill passed, it's another thing to get people out. So.
Thank you so much for this overview and for this great work. And it's really brings hope to hear about these numbers of folks that have gotten resentenced. So that's terrific. Can you tell us about if there's been interest that you've received from advocates and legislators in other states to bring about similar reforms?
Yes, definitely there has been. We've been working with, or, in connection with a group in Minnesota, and they've been doing some great work. I connected with Marshan's organization in Illinois a few years ago, Restore Justice Illinois, around their reforms. Our bill, SB 1437, the same, almost the exact same bill was introduced by a Florida legislator some years ago. And I know that there has been a lot of interest in Pennsylvania as well, around instituting these reforms. I will say that yeah, as we were thinking about it, when one of your slides you had about like a weak reform, you know, there it was really helpful to have a legal background, a criminal defense background, because some of the things, you know, well, if you're armed or you knew that a co-participant was armed or some other factors that you could put in to find someone guilty of felony murder. I mean, I knew, you know, from my experience, you know, one interview in a police station and that's it. You know, you can get a kid to say, yeah, I knew he was armed, or I thought he might have been armed, or yeah, exactly. And then it's not, you know, then he's good for felony murder. So really we wanted to make a much stronger intent element in it.
Thank you so much. So such a great model from California, and still more work to be done, which we might get a chance to talk about later. But for now, let me turn it over to Monica. Thank you so much for joining us. It's been really wonderful to have Fair and Just Prosecution as a partner in this work. And so I'd love to hear from you about why FJP sees felony murder as an important issue, and what are some of the ways that prosecutors can or are addressing some of the problems with felony murder laws in the absence of legislative reforms.
Absolutely. Thank you, Nazgul. So felony murder laws and the extreme sentences associated with them come at a tremendous human and financial cost. They promote unjust, harsh results, and they fail to deter crime or otherwise promote public safety, as we've already heard. So, you know, I'll skip over some of the things that Nazgul and others have touched on about how fundamentally unfair they are, how they result in extreme and harsh punishments, including often life in prison without parole and even death sentences, which violates our principle of proportionate sentencing and fuels mass incarceration. And then they have not been shown to be a deterrent, as Nazgul mentioned. That is typically a primary justification, but the available data we have does not support that. And if you just consider it, if people are being held responsible for a death that they didn't actually commit or intend to commit, it would be a little bit strange to presume that a harsher punishment could have deterred them. So not surprisingly, there's no proof that these laws have reduced the number of felonies that have become deadly or served as any kind of a deterrent. And they also come at a tremendous human cost, which Marshan really clearly laid out for us. And we also discussed the ways that these laws have had a particularly harsh impact on young people, women, and people of color. And then I'll also add that we are an international outlier in our use of felony murder. The United States is the only country in the world that utilizes the felony murder rule. It originated in England, but they abolished it over 50 years ago, and as have most all countries since then. So that just goes to show that our use of these laws in different states, it's anomalous. And internationally, there's recognition that it violates the principles of justice and proportionality, and that the lengthy sentences that are associated with them are often cruel and unusual. And then the key point here is that, as others have mentioned, we can still hold people accountable without these laws. So abolishing felony murder will not result in a lack of accountability. In fact, it will just ensure that people are held accountable for their actual actions. So if a person is responsible for a killing that happens during a felony, they can be prosecuted for first or second degree murder or manslaughter, depending on their mens rea, other statutes, depending on the specific state. And if a person participates in a felony where a killing occurred, but they had nothing to do with the killing, then we can just hold them accountable for their specific action, for that specific felony that they engaged in. So we know that prosecutors can be leaders in this area. absent kind of, as you mentioned, Nazgal, absent a full repeal of felony murder laws, prosecutors have a number of options available to them. So at the very least, they can introduce a mens rea requirement for felony murder of at least reckless indifference. Another area to be thinking very critically about are their charging and plea practices. So, as I just mentioned, they can choose to forego felony murder charges and just charge the individual with the actual offense that they committed. And they should also be certain not to try to leverage or coerce a plea deal using felony murder charges. Prosecutors also shouldn't be pursuing accomplice liability, and they should take into account evidence that the accomplice may have been acting under coercive control, as so often happens in instances with women or situations involving domestic violence or human trafficking. Prosecutors should also not be seeking death and life without parole as sentencing options, and they should protect minors and emerging adults from the felony murder rule, given what we've discussed about the differences between young people and adults. And then they should look into their past charging and plea practices so that they can track and identify any racial or ethnic disparities. There's very little data around felony murder, especially in prosecutors' offices. So it's very important for them to be tracking and have an awareness of how their office is using those charges. And then I'll just add, as far as sentencing practices, prosecutors can also on the front end limit the imposition of extreme sentences. So for example, last year in New York City, DA Alvin Bragg enacted a policy to prohibit LWOP sentences and cap determinate sentences at 20 years. Other prosecutors have also enacted similar policies. And just a couple of years ago, we had over 40 elected prosecutors who signed on to a statement calling for office policies where no prosecutor would be permitted to seek a sentence above a certain number of years, typically 15 or 20, without permission from a supervisor or the elected prosecutor, him or herself. And then given that it is April, Second Chance Month, prosecutors can and should also reconsider previously imposed lengthy sentences. So over 60 reform-minded elected prosecutors and law enforcement working with fair and just prosecution have called for second look legislation, and several prosecutors' offices have launched sentence review units. So they are starting to look back and figure out how they can remedy past unjust sentences. And this is something that Fair and Just Prosecution and the Sentencing Project feel very strongly about. And we do recommend instituting a second look and automatic sentence review process within a maximum of 10 years of imprisonment. And I will just add that there is broad public support for second chances. So this is not something that needs to be done kind of in a vacuum or feeling like there will be a tax. There is a lot of support for these changes to be made.
Thank you so much. You covered a lot of ground, and that was really helpful. So let me turn over to Justin. Justin, you previously served as a prosecuting attorney for the County of Kauai in Hawaii, one of the very few states without a felony murder law. Can you tell us about how cases that are prosecuted under this law that we've been discussing, have been getting prosecuted unjustly? How would those kinds of cases, or, a hypothetical one that you might want to highlight, how would it be handled in Hawaii without the felony murder doctrine?
Yeah, sure thing. And thanks for asking me that question. As we've noted, Hawaii has never had a felony murder rule. I think in large part that is due to the fact that the penal code there is largely based on the model penal code. It was not adopted until well after statehood in 1959. And at the time, Hawaii had a very progressive legislature and has long had a very progressive judiciary. So given the NPC's kind of harsh treatment of the felony murder rule and coupled with the progressive legislature at the time, it just became baked into the law very early on in statehood. When we would see cases of murder, almost all cases in Hawaii are prosecuted as second-degree murder, which maximum penalty is life with the possibility of parole. Subject to certain enhancements for unusual circumstances that are rarely used. And we would, in situations where there may be some level of culpability incurred by other participants, those cases could conceivably be charged as conspiracy to commit murder, which would carry the same overall punishment level as the murder charge. But that would have to be in situations, of course, where there was a true conspiracy to commit the murder, meaning an agreement to actually kill somebody and a substantial step in furtherance of that. Or alternative theories of liability, including the usual ones: accessory liability, accomplice liability, attempted, liability for an attempt, which again carries the same penalty as if the crime was completed. So, but again, there has to be a nexus of some intent, some agreement in furtherance of the crime. But in situations where we were unable to establish that, level of culpability, if there was other felony conduct, such as, concealing evidence or assisting in, procuring a firearm or something like that, those are all criminal charges that stand on their own, and nothing prevented us from charging those cases in appropriate circumstances. But I think the underlying intent was clearly to ensure that there is an, individual scrutiny of specific situations to make sure that the law fits the facts, and the facts fit the law and the punishment at stake. And so, that led us to the lucky position we were in Hawaii.
Thank you so much. It's the felony murder rule is just so widespread across the country that it becomes hard to imagine how states operate without it. But what you explain seems so clear and sensible. So appreciate that you can provide that perspective. And so now I want to ask you a question about your current role at FJP and working with prosecutors. And I'm wondering if you have insights that you can share about the kinds of obstacles that prosecutors might face in creating and implementing felony murder reforms and how they can be overcome.
Sure thing. I brought that experience as a prosecutor, not just as an elected, but also as a line prosecutor earlier in my career, and look at my work at FJP through that lens as well. Some of the obstacles that prosecutors face in implementing these reforms is, a culture and punitive mindset that simply takes time to change. Electeds come and go and have different policy priorities, but the folks who are the line staff in the office tend to be there 10, 15, 20, 25 years. And so they may have a mindset that was baked in many years ago, and that's something that guides their actions through the current time, even though we have access to all this additional data and research that's happened in the ensuing decades. And, also, frankly, an aspect to the culture that says we're not supposed to consider these external policy considerations. We're supposed to, we're wearing the white hats. We're fighting on the side of good. Other people can come in and make the arguments in favor of the defense, and then the judge decides. But it's our responsibility to simply look, the law provides for this. The person did something that falls within this charging language. And so, we've got a duty to go forward and charge these cases. And unfortunately, that mindset does still persist in many offices, large, small, across the country. And the electeds, when they come in, even if they want to execute those policy shifts, as many do, those who work with us and others who are outside of our orbit, they have to deal with that blowback inside their office. They have to pick their battles. They have to deal with media scrutiny and backlash and harmful narratives out there. So I think a lot of times they feel, that has a chilling effect on their ability to implement really dramatic changes, not excusing that, but explaining it. And I think there's also a widespread fundamental misunderstanding of what victims and survivors of crime truly want. Historically, the voices of victims who favored restorative practices, that those voices have not been lifted up, and prosecutors who are invested in maintaining the status quo will typically, use victims' voices as, in quotes, as kind of a monolithic cudgel that they use to beat back any consideration of constitutional rights or propriety or proportionality in charging and punishment. So it's only been in recent years that we start to see some pushback against that, but even so, it's still very halting in most places. And, victims' voices are portrayed as wanting maximum punishment, wanting maximum retribution, even though that is simply not the case, particularly in the communities that are most affected by violence and violent crime. We find that there are other voices out there. And, I think part of our job is to lift up and center those voices so that we start to change that kind of monolithic perception. I think many offices also don't have access to the data as to how, this has been historically implemented in their jurisdictions. I think lots of folks would be surprised to know how much space in their jails and prisons is being occupied by folks who were convicted under these draconian laws 20, 30, 40, in some cases years ago. They're focused on what's in front of them. Prosecutors will typically, once a case has been sentenced, they will forget that it ever existed. And so it'll go and, it'll be marked with a C for closed and go into the archives and never to surface again unless there's a parole hearing or some such where they will crank out a boilerplate opposition to any relief that the parole authority might offer. So again, just a failure to recognize that obligation to seek justice persists beyond a conviction in the case and any perceived closure. And the prosecutors really have a duty to make sure those convictions and sentences that they've sought, have integrity and stand the test of time, even if they happened 10, 15, or 20 years ago. I think, there's also, as I mentioned earlier, just a lot of legislative pushback and political pressure on these DAs, and they may have, 10 things that they would really like to change in their office, but there are maybe 3 or 4 that they think they can plausibly accomplish during, say, their first term in office, or, maybe less than that if they've got, a staff of prosecutors who is constantly pushing back and in some cases filing lawsuits because they don't want to follow policy changes. So again, we see the limitations of, a system that elects the person at the top of the office, but makes it very difficult for that person to align their staff with their values and ideals and the values and ideals of the communities who elected them and put them in that position. I know we're running a little short on time, so I'll wrap that up and allow us to move on. But yeah, thanks again.
Thank you. I think that you actually answered several of the questions that I saw from audience members that I was going to pose. So in particular about how to consider when the perfect victim, as someone put in quotes, is presented as an obstacle to reform. Folks also asked about getting data on felony murder by age, race, gender, disability. There is very limited data on these factors, and so reach out to us if there is a particular jurisdiction that you're interested in. We can see if we know of any information out there on it. I know that the Boston University Center for Anti-Racist Research is also working on this particular issue of felony murder and collecting data from around the country, so I can help to connect you with them. And then I want to close with this one question, and I appreciate all the conversation in the chat and that some of the panelists have been responding to some of those questions there. But there's one question I wonder if some of the panelists want to address, which is, presuming you could pass comprehensive and retroactive legislation that abolishes felony murder, how do we bring a restorative justice approach to heal the damage brought on by a loss of life? And so I'm wondering if any of you have reflections on how we move towards a model that gets rid of injustice but offers some restoration to victims and victims' family members. Any thoughts on that you'd like to share?
I guess I can say, I mean, it's really difficult. It's really difficult, and I'm speaking somewhat of my experience coming out of a district attorney's office, and working with victims, and especially in the immediate aftermath. It's very, very tough to have those conversations. I will say that what we did see in 1437 was we actually had family members of victims that either came to court or spoke to the media when they were contacted on a resentencing that were supportive of the resentencing. And they, you know, understood that in the case of their loved ones, it was unintentional, like it doesn't obviate the pain, but it was not intended by the person. And that went a long way to that. Now, of course, that was after often many years later. So I think it's a point well taken. I just it's very difficult, and our system, maybe as Justin has, you know, indicated, it's not really set up at all for restorative justice at the onset. We did a lot of it. We attempted a lot of it in San Francisco, and it was great and worthy work, and we got really far in a lot of ways. But it's the system itself isn't set up with that in mind. It's set up with punishment as the primary goal of the criminal system, and not true assistance for victims.
Yeah, I'm sorry.
Go ahead,
we're out
Marshan.
of time. I just wanted to add, like, echo everything Kate said. And one of the ways that the system makes it difficult, like even like bringing up Lakeith case again, where the victim's family, Adante's family, actually testified at the court saying that they didn't want him, he should not be in prison, that they don't hold him accountable for his son's death, and he should be at home with his family. But the judge ignored that. You know, and sometimes our system, they listen to the victims, in which they should, but they listen to them when they're calling for stricter punishment, but they're often ignored when they're calling out for a sympathy or mercy. And it definitely needs to be something more added to our system where those voices are heard as well and counted for.
Thank you so much. Thank you to all of the panelists for sharing your time and expertise and wisdom with us. And to respect everyone's time, I'm going to wrap us up now. I look forward to more discussions and work with you in the future. Take care.
Thank you.